calling the matter of CP 2024-28, Agostini Insurance Brokers Limited against Trinidad and Tobago Civil Aviation Authority and Gallagher Insurance Brokers Trinidad and Tobago Limited, interested party.
Good afternoon, everyone. Ms. Rose, you may continue with the witness that you were about to call before we took the break. Ms. Rose, you unmute one of your devices. If you said anything a while ago, I wasn't hearing you.
All right, that's something here now.
Mr. Chairman, are you hearing me now? Okay. This device needs to be put in front of. And please turn off all sound and stuff off of those. Yeah, Mr. Chairman, Ms. Sunita Pabu, Ms. Sunita Pabu is here in the room, please.
Good afternoon, Ms. Pabu. Could you please repeat after me?
Sure.
I,
Please
state your name,
Sunita Pabu,
do solemnly, sincerely, and truly affirm
do solemnly, sincerely, and truly affirm
that the evidence I shall give to the hearing panel
that the evidence that I shall give to the hearing panel
in this case shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Ms. Rose? Yeah. Sorry, Ms.
The witness is tendered for cross-examination, please, Mr. Chairman.
Thank you, Ms. Rose. Ms. Fitzpatrick?
Thank you. Ms. Pabu, you have been employed with Civil Aviation since 2011, but appointed Manager Human Resources in 2017. May I ask, what was your role between 2011 and 2017?
So clerical assistant, then acting clerical officer 2, then human resource officer, and then manager HR.
Okay, so did you have anything to do with the administration of the Group Health and Life portfolio prior to your appointment as Manager Human Resources?
I would have assisted in terms of the Group Health and Life at the level of human resource officer.
Okay, so I am aware that there has only been, or the most recent transition from broker for the Group Health and Life Services was in 2012. Were you involved with the administration of the portfolio at that time?
No.
Okay. You have given evidence, Ms. Pabu, that the renewal of contract policies, and that is third-party contracts, yes, that's with the insurers, can take 1 month.
Right, that is subsequent to the selection of a broker.
Correct. Good. And at paragraph 9 of your witness statement, you testify that the transition from one broker to another broker can take 6 weeks.
Correct.
So we're looking at 6 weeks plus a month?
Because during the 6 weeks process, right, the broker would do the necessary recommendations as regards to contract renewals for the authority.
Right. So I was asking whether when you say it takes 1 month, if that is at the end of the 6 week transition period, or no, it's encompassed in the 6 week.
So it all depends in terms of the transfer of the information from the broker, from the insured company at that time, to the whoever is the selected broker.
Okay. So I would like to take you, please, to the letter of appointment dated 29th August. That's a letter appointing Gallagher Insurance Brokers Limited. And IT, it is page 64 of tabs 9 to 20 attached to the witness statement of Mitcham Narayan Singh. Yes, so if we can scroll down just a little, please. This is dated the 29th of August, Ms. Pabu, and this is the letter which serves to appoint Gallagher Insurance Brokers Limited as the insurance brokers for the group health and life and general insurance portfolios, yeah?
Yes.
And it says in the third paragraph, in the interim, so that is before the appointment as brokers effective on the 1st of October, which is when the policy contracts renew. In the interim, GIBL is hereby authorized effective immediately to negotiate directly with any interested company with respect to changes in any existing insurance policies, I beg your pardon, and in binding, endorsing, renewing, cancelling, or any other transactions for all property and casualty insurances and also group health, life, and employee benefits. So that it's this period that you're talking about for the 1 month period that you're talking about.
Right.
The one-
Because right, correct. Because subsequent to the selection of the broker, right? Only then thereafter we would know that when we engage the broker, whether or not during the renewal process, if it is that is likely for the authority to be changing insurance providers.
Okay. And when this letter of appointment is sent, there are obviously existing insurance policies that are not yet at an end, yes? Because they're coming to an end at the end of September, is that correct?
Correct.
And the broker can negotiate any changes to those policies, but there may not be changes. Is it fair to say that, to assume that there may not be any changes to those existing policies?
It is not fair to say that, sir.
So there may be changes to those
Correct.
policies.
Yes.
Yes, okay. But I know what I'm asking is not always. There's not always changes to the policies.
And most times there are always changes, be it whether
the
in
end-
terms of changes to premiums and so forth.
For the month that remains?
No, not for the month that remain, in terms of for the new period.
Right, sorry. So what I'm asking is, it says that they can negotiate directly with any interested company with respect to changes in any existing insurance policies. It may be the case that there are no changes in the existing insurance policies.
You remember you said that this is coming to the end of the insurance that we have right now, right?
Yes.
Which is on September the 30th.
Yes.
So if it is that the broker have to negotiate changes, right? The current broker cannot negotiate changes for the current insurance portfolio that would end on September the 30th. The broker will have to negotiate for the period that going forward, which is effective October the 1st.
Well, so that's why I'm showing you what that paragraph says. That says with respect to changes in any existing insurance policies. And then it goes on to say, and in binding, endorsing, renewing, cancelling, or any other transactions. But that suggests that they can negotiate with respect to existing insurance policies.
Yes, effective October the 1st.
No, hold on. Ms. Pabu, the first paragraph, the
Right.
second paragraph says this serves to record the appointment of GIBL as our insurance brokers on all matters involving the control and management of all insurable risks effective October 1st. Yes?
Yes.
And then it's in the interim. So before October 1st, in between 29th August and October 1st, they are hereby authorized to negotiate with respect to any changes in existing insurance policies.
Correct.
Okay. And the existing insurance policies will subsist until the term comes to an end. So the existing insurance policy continues until the 30th of September. Yes?
Yes, yes.
And that is not affected by the transition of the broker.
Correct, because that would be the current broker that we have engaged up until September the 30th.
Right. May I please take the witness to, sorry, I beg your pardon, before we move on from this, Ms. Pabu, the date of this letter being the 29th of August, do you accept that there was less than 6 weeks for a transition from broker to broker?
We would have verbally engaged Gallagher on the 16th of August.
And do you accept that from the date of this letter of appointment, there was less than 6 weeks for transition from broker to broker?
Correct, the 29th of August until the 30th of September, yes.
Yes. And this letter doesn't seem to suggest that there's any urgency with respect to the renewal of policies, does it?
Well, it did state in terms of we engage in Gallagher, so the word urgent was not used within the letter. However, at the meeting that we would have had with Gallagher on the 26th of August, we did suggest to them that it was with urgency.
Okay, and where do you talk about that meeting in your witness statement?
I do not think the dates in terms of the 26th of August was recorded in my witness statements.
Did you talk about the meeting in your witness statement?
No.
Okay. Now, at paragraph 15 of your witness statement, which I would ask IC to please pull up. Now you talk, Ms. Pabu, about the considerations which influenced the respondent's decision to proceed without the standstill period in that paragraph there, at paragraph 15. And you talk about the experience with transitioning insurance service providers. You see that?
Okay.
First
Yes.
thing, that experience that you refer to there is not experience that was gained between May 2024 and August 2024, is it?
Correct. That was experience in 2023.
Well, I actually think that's dealing with the second consideration. But with respect to the first consideration, the experience with transitioning insurance, the transition of the service providers, we know that the respondent has almost 2 decades of experience maintaining the insurance portfolio and has, during that time, had experience with transitioning the insurance service providers, correct?
I'm not sure who you're referring to in terms of 2 decades of experience. Is it that you're referring to Guardian in terms of that?
No, the respondent, sorry, being civil aviation. Perhaps, Ms. Pabu, in fairness to you, perhaps you are not familiar with that. So I won't pursue that question. But in answer to my question, whether the experience with transitioning insurance service providers is experience that was gained between May of 2024 and August 2024, you said no.
Correct.
And you refer also to the consideration, the denial of the request by the previous insurer, that was Guardian Life, GLOC, that's Guardian Life, correct?
Yes.
And that is one experience in 2023, is that correct?
Correct.
And when that took place, the respondent was in any event able to secure the transition to Sagicor, yes?
Yes, with the assistance of the current broker, we was able to transition to Sagicor. However, they had some challenges within that transition period.
And where do you talk about that in your witness statement?
That was not incorporated in the witness statement.
Okay. And again, that experience of the denial of the request by the previous insurer was in 2023. So that was an experience that was known to Civil Aviation at the time that the request for proposal was issued, correct?
Correct.
And you also indicate that one of the considerations was the ramifications for any lapse in coverage. And we have heard we've seen in the submissions that these ramifications, Ms. Pabu, have been described as catastrophic. Yeah. These are not ramifications, Ms. Pabu, that all of a sudden arose after May of 2024. Are they?
No, it would have been considerations that we would have taken in light of the RFP and the timeline.
Well, wouldn't it also have been considerations that would have been known to the respondent based on its specialized knowledge of the risk of a lapse in insurance coverage?
The authority would have done the necessary to ensure that we wouldn't have to go to the ramifications of not having insurance for our employees.
But they didn't go through that pre-RFP, did they?
No, because when it is that we would have advertised in terms of May and based on the timeline that we would have set out, we would have had sufficient time in terms of executing to ensure that there was a smooth transition from one broker to the next and whether or not we would have to change in terms of insurance providers.
Okay, so Ms. Pabu, no one has really given any evidence as to what changed. And the evidence that you have given is that these considerations came up and you thought you would proceed without a standstill period because your experience with transitioning insurance service providers was such that you could not maintain the standstill period. You had experience with the denial of the request by a previous insurer, and there was a risk of ramifications of any lapse in coverage. And all I'm trying to understand is, were those matters that the respondent was not aware of at the time that the RFP was issued?
No, the respondent would have been aware of it because this would have been our experience last year.
Thank you. I have no further questions for this witness.
In response to, Mr. Chairman, I do have a couple of questions.
Please proceed.
In response to my learned friend, representative for the applicant, you indicated that authorization for the broker would have been issued, yes, by that letter of appointment. Did you have any communication with the broker about the intention to award prior to August 29th?
Yes, we would have had a verbal conversation with the broker in terms of Gallagher on August the 16th.
On August the 16th?
Yes.
And you said there was also a meeting on August the 26th?
Correct.
And what considerations were raised with the broker on August the 16th?
That we need to engage their services as soon as possible to ensure that the authority does not have any lapse in coverage in terms of the group health and life policy, as well as the other policies, which was the aviation liability and the general insurance.
Now, you were trying to explain to Millen Friend on behalf of the applicant that there are always changes to policies coming to the end of year. Can you explain that response?
So there wouldn't be any changes in terms of coming to the end of year. However, the broker would negotiate with the insurance companies should there be changes or change in insurance company for the new fiscal year for coverage.
Does that have anything to do with the risk profile changing?
Right. So in terms of the end of the year, the insurance company together with the broker would assess the authority's risk ratio. And based on that, they would know in terms of whether or not we would have changes, if in terms of whether or not our premiums would increase for the different categories of the insurance.
And that would be based on what occurred during the course of the year of coverage before.
Correct.
Nothing further, please.
Ms. Sina, do you have any questions for the witness?
Yes, please, I do. You were just asked as it relates to the risk ratio, right?
Correct.
Are
Yeah.
you aware that there were any changes that would have been needed to take into account?
We would have had employees during that time in the month of September that was on international travel that would have engaged in medical emergencies that I know for sure would have been a certain amount of a claim.
Thank you. No further questions for this witness, please.
Ms. Rose, any re-examination?
No, no, please, Mr. Chairman.
Thank you, Ms. Rose. The witness may now be relieved.
Okay.
Grateful. Mr. Pearson. The respondent now calls Mr. Felix Pearson. Mr. Chairman, Mr. Felix Pearson is now before the panel.
Thank you, Ms. Rose.
Good afternoon, Mr. Pearson.
Good
Please
afternoon.
repeat after me. Hi,
Hi,
please state your name.
Felix Pearson.
Do solemnly, sincerely, and truly affirm
Do solemnly, sincerely, and truly affirm
that the evidence I shall give to the hearing panel
that the evidence I shall give to the hearing panel
in this case
in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
The witness is tendered for cross-examination.
Thank you, Ms. Rose. Mrs. Patrick.
Thank you. Good afternoon, Mr. Pearson. I just have a very few short questions for you. Mr. Pearson, you gave evidence that on or around the 5th of August, 2024, Ms. Gabriel presented certain concerns to you about the timelines for completion of the procurement process. You recall that?
Yes, I do.
And that
1 minute, please. 1 minute, please. I would like us to be very fair to the witness. Please, can the witness be shown where in his statement he indicated that Ms. Gabriel?
Yes. Yes, that's at paragraph 7 of the witness's witness statement, please. Yes.
Noted. Noted.
Mr. Gabriel, you say at paragraph 10 of the witness statement that given the concerns expressed and the gravity of the situation, you immediately convene a meeting of all parties concerned with the procurement process to review the timelines and determine how the concerns expressed could be alleviated. Now, in your review of the timelines, you say at paragraph 15 that the meeting considered a plan to expedite the remaining internal processes by ensuring that they received top priority at every stage. And if we perhaps just stop there, when you say the meeting considered a plan to expedite the remaining internal processes, do you mean a plan to ensure that the procurement could be completed on time with the standstill period remaining?
Right. Our initial plan for this tender really surrounded an outline, a timeline that we had set. And that timeline started from the date for the submission of tenders, which was originally the 21st of June. So we had a timeline established for the completion of this procurement process. In the course of the tendering, we had requests from 3 proponents for extensions, so we had to make
Sorry, I'm sorry to interrupt you, Mr. Pearson, but I think we're getting away from what my question was. I was asking whether, with specific reference to paragraphs 15, and maybe I'm sorry that you haven't been able to see it. IT, could we please just see paragraph 15? That we're talking here about the meeting on or around the 5th of August. And you say you considered a plan to expedite the remaining internal processes by ensuring that they receive top priority at every remaining stage. And my question is just about the plan that you're discussing here. Is this plan you're talking about here a plan to try and maintain to secure the procurement without the need for the standstill period? Well, sorry, keeping the standstill period?
Mr. Chairman, may I?
Proceed, Ms. Rose.
Yeah, I'm objecting to the attempt at circumscribing this witness's response. The counsel is asking this witness about what was considered in terms of a plan to expedite the remaining internal processes, which is the first sentence of this paragraph. And the witness is responding about what was considered in terms of the plan to expedite the remaining internal processes. My learned friend cannot circumscribe the witness's answers. So I'm asking in all fairness that this witness be allowed to answer. This panel must have assistance as to what was going on in the minds of these decision makers in respect of this procurement proceeding, and not have some circumscribed court machinated answers, right? Courtroom machinated answers, please, Mr. Chairman. The panel must be assisted so that they can make appropriate decisions in this particular procurement proceeding.
Mr. Chair, may I?
Fitzpatrick.
Yes, sorry, Mr. Chair, the witness has filed a witness statement so that one should assume that if there was anything he needed to say with respect to the process, it would form part of this document. But in any event, I understand that Mr. Pearson has started to give an explanation. I'm not trying to circumscribe or all I'm trying to get at is that before we even get to what Mr. Pearson is answering, I am trying to get an understanding of what exactly is he saying in this sentence.
And he's trying to give that answer.
Well, I don't know that my learned friend can say that. I have heard what he is saying, and I know the question that I'm asking, and he has not answered that question.
Yet.
I am simply asking, and if the panel is unsure about anything, of course, the panel is well within its right to ask those questions. My question was whether the plan that he's talking about there, simple, is that plan in that first sentence, are you talking about a plan to maintain the procurement timeline? That's my only question. Is that what you're referring to there? And then we can get to what the discussion may have been. But I am trying to understand, when you say a plan, is that what you're talking about? He has started giving a long narrative, and I think, you know, my friend was very clear on Friday that I could not tell her how to conduct her cross-examination, and I would appreciate the ability to ask the witness the question.
And I would say, Mr. Chairman, I think my conduct today would demonstrate unequivocally that I've allowed my friend complete leeway to ask whatever questions and to treat with the witnesses in whatever manner she saw fit. However, even the last question that she just asked is different from the question that she asked before that the witness was responding to. So if you can get just real clarity on what is the question that this witness is being asked to respond to, and we can move forward, please, Mr. Chair.
Thank you, Ms. Rose. Ms. Fitzpatrick, allow me a brief moment to speak to the panel and we will respond shortly.
Thank you.
Ms. Fitzpatrick? You may
Yes.
re-ask your question, allow the witness to answer, and ask further clarification questions if necessary.
I'm grateful. Thank you. Mr. Pearson, at paragraph 15 of that witness statement, you say in the first sentence, the meeting therefore considered a plan to expedite the remaining internal processes by ensuring that they received top priority at every remaining stage. And I'm asking you whether the plan that you're considering here was intended to maintain the standstill period. Were you trying to maintain the standstill period and still meet the completion of the procurement? Was that what you were trying to do?
The plan that the meeting considered was really how we can achieve the deadline date of September the 30th for having all policies in place without any lapse of coverage. And the context I was creating to that response was to say that we had examined the timeline for this procurement process, beginning with at one point having 14 weeks for the completion of this procurement process. That would have been reduced to 12 once we accepted a request from all three proponents for an extension in the deadline for submissions, and we did allow that. From that point, we understood that we needed to pay very close attention to the timelines, understanding what was involved in the completion of the process to ensure that by September 30th, all policies would have been in place. We had an opportunity to review that in July. On July the 4th, the day before the submissions were due, to examine where we were with respect to the timelines. And at that point, internally in our planning, we had determined that July the 19th was the date that we will set to have this process completed in order to meet what we understood to be fairly inflexible timelines for the completion of the process. So that when Ms. Gabriel came on about the 5th of August, expressing concerns that we were behind with respect to the timeline for completion, the concern really was with respect to our ability to have those policies in place by the 30th of September. So our consideration there really was what did we need to do to ensure that we could meet this inelastic deadline of September the 30th. And we did consider all the internal processes, and the conclusion was that yes, we needed to find a way to expedite because we understood that there was a difficulty in meeting the timeline as prescribed.
Thank you, Mr. Pearson. So you, for the first time, given evidence about a meeting that took place on the 4th of July. That's the day before the bids come in. Or
yes,
the day before the virtual opening, yes? You
yes,
haven't given
such a meeting.
Yes, and you didn't say any of that in your witness statement.
No, it may have been omitted.
Okay.
Mr. Chairman, I'm going to have to, interject again and object to this. It's an argumentative approach with the witnesses. This is a truncated procedure, 20 days, in which on the 4th of October, an order was made for the witness statements to be filed by the 8th. And in between the 4th and the 8th, there was a weekend. So there was really 1.5 working days to file these witness statements. So it is entirely argumentative and unfair of Ms. Fitzpatrick to put to the witnesses that they didn't put that in their witness statement. This is the hearing that we have so that these issues can be aired out and explored properly so that the hearing panel can be satisfied about the processes that were engaged in respect of this procurement proceeding. So I'm objecting to the witness being castigated for not putting things in a witness statement when we only had 1 day and we were intending to try to file 8 witness statements. We eventually filed 5 and then another one on another day. Please, we were under significant constraints. So it's not fair, please, Mr. Chairman.
Mrs. Patrick, I will hear you before we give the panel's decision.
On
the objection.
I'd first just like to say that I will ask my friend if she's making an objection, please to ask the witness to leave the room, because my friend has made a submission in which she has included certain evidence that has not come out on the witness's witness statement about time and weekend and so on, and I don't think that that is right. The other thing that I will say is that there is nothing that precludes me from cross-examining the witness as to what is not included in the witness statement. The timelines notwithstanding, because the parties have all had to comply with these timelines, and this information is well within their knowledge. But it is relevant because what it does is it highlights that all of this information, it is absolutely incredible. It could not be that this took place and this was such an important matter, or that this was relevant to these proceedings and you did not include it in your witness statement. There are certain inferences that ought to be drawn from it not being included in the witness statement. And I do not know why I would not be allowed to ask the witness that question. He simply said no. And my friend has now given a long explanation as to why. So the panel can accept that explanation, but I can ask my question.
Thank you, Mr. Fitzpatrick. Ms. Rose, are you making an objection?
I maintain my objection to the badgering of a witness about what is not in a witness statement in a truncated procedure when we had a day and a half to put in witness statements. It's just simply unfair.
And I would like to say for the record that I take serious umbrage with my friend suggesting that I am badgering any witness. I have been nothing but cordial and respectful to Mr. Pearson. I asked a question and he answered the question, but that is not, that I really think that is a very unfair thing of my friend to say, that I'm badgering the witness.
Okay, so thank you, Ms. Fitzpatrick. Thank you, Ms. Rose. The panel will take a short break, a brief moment. Don't go off screen. We'll be right here to discuss, and we'll be back shortly with our response. Ms. Rose, we will
Yes, Mr.
allow
Chairman.
the panel has decided that we will allow the question to be asked, and we also note that the date was brought up by the witness in his response to the questions of Ms. Fitzpatrick.
Much obliged, please.
Thank you, Mr. Chair. Mr. Pearson, I just have one further question for you. There were no plans to expedite the process between the 4th and the 5th, between the 4th of July and the 5th of August. No plans discussed.
Because when we looked at the timeline, there was a plan to expedite to the extent that we had determined that the 19th of July will be the date that we set for the completion of the process of the award and the PDAC deliberations. So we had determined that the 19th of July would have allowed us 10 weeks for us to proceed to complete the procurement proceedings. So in that context, we had sufficient time. So July the 19th, and that would have required the process to be expedited within 2 weeks, where we would have had the evaluation, the PDAC, and the accounting officer's approval. It is because we were unsuccessful in achieving that expedited process that we found ourselves exposed on the 5th of August, having not yet completed the evaluation. The evaluation was just about completed, with still the PDAC and the accounting officer's approval stage outstanding. And it was in that context as well, when we examined, we looked and we saw, as at the 5th of August, we were down basically to 9 weeks remaining before the end of September. We considered, again, we asked that all remaining stages be expedited, and we set ourselves a very ambitious timeline to have that process completed within another week. And that would have left us with 7 weeks remaining. And it's in that context that we determined if we were to allow 2 weeks for the standstill, then we'll be down to 5 weeks. And there's no way, it would have been totally impractical and infeasible for us to complete the process, to have policies in place by the date of September.
So when the date for the original date, July 19th, came and went, there was no concerns raised before the 5th of August.
Right. Yeah, we did look at it operationally because the concerns really was around the evaluation process. The evaluation committee did not anticipate having to go out for additional information clarification, and they had to do that. And it took them a while to get that information. When it came in, they evaluated, and we are very careful not to appear to interfere or prejudice the evaluation process. So we did ask the evaluation committee to expedite, but we sought not to interfere with that process, and we trusted that they would have accepted that challenge to expedite, understanding the need to facilitate an expedited process.
So am I understanding that the delay was as a result of the evaluation committee?
But I wouldn't say delay, because as I said, we had set a very ambitious timeline for the evaluation committee. The evaluation process turned out to be a fairly complex one from 2 perspectives. One, this was the first time we were dealing with this consolidated portfolio, so it required much more involvement and engagement in terms of the analysis. It transcended 2 different departments, the HR department and the corporate planning department, with different portfolios. So we had different parties involved in that evaluation process. It turned out to be fairly complex, and they needed some additional information. So notwithstanding our ambitions to have it completed, it turned out from a practical point of view that they needed more time than we would have imposed on them to complete that process.
Thank you, Mr. Pearson. I have no further questions for this witness, Mr. Chair.
Ms. Rose, do you wish to re-examine?
Mr. Chair, I wish to make an application under the Office of Procurement Regulation Hearing Rules and Procedures to lead more evidence through this witness, please. I'll be relying on Hearing Rule 8.4, that at any stage in the challenge proceedings, the hearing panel may order that a party provide to another party and to the hearing panel such documents as the hearing panel considers necessary for a full and satisfactory understanding of the subject of the proceedings. The general powers of the hearing panel in respect of receiving additional evidence. I will also be relying on the overarching objective, the overriding to deal with matters fairly and justly. And I know my learned friend will be taking the point, but we are being ambushed by information now. I would respectfully submit that there is no ambush on this issue of the risk of cancellation. This witness has given, and this is what I want to elicit further evidence on. This witness has given evidence on the risk associated with the cancellation of the process. And I'm respectfully asking the opportunity for him to be able to elucidate for this hearing panel so that the hearing panel can make a decision that is fair and just, having regard to all the information, all the relevant information. I'm asking that the hearing panel allow me to ask this witness a few more questions, only as it relates to the risks associated with the cancellation of this process, because this is an application that the applicant has made in its Form 8, and we would like, as the respondent party here, to be able to provide all necessary information, despite the exigencies of the truncated timeline in this process. So I'm asking on, yes, please. ma'am.
Mr. Patrick, before I hear what you raise your hand for, Ms. Rose, I have a question. Is it that you're introducing additional documents, or do you wish to refer the witness to existing documents already filed?
Referring the witness to existing documents and his own witness statement to explain some of the things he has put in his witness statement, please. ma'am.
Ms. Fitzpatrick?
Yes, Mr. Chair. Mr. Chair, my friend is correct that I am objecting, and I am relying, please, on Rule 9.9 of the hearing rules, which says that a witness may not testify to material matters that were not disclosed in the witness statement or statement of evidence without leave. And of course, the consideration is always what is just. My real issue, please, Mr. Chair, is that it seems, especially based on the tenor of the application, that this is material information, and one must ask why, if it is so material to the reply, was it not included in the witness statement? I respectfully, it is not sufficient to say we did not have time. If this goes to the heart of the matter, then it is something that ought to be included in the witness statement by the date for filing. And in addition to that, say simply that it is not fair, because this is coming at a time, please, when the applicant has closed its case. So really what is being done here is an attempt now to introduce evidence really in response to what has been said. And that I say simply is not fair. I don't know that I can through this submission.
If I might be maybe permitted to respond before the panel considers this issue. As the honorable panel is aware, in this matter on Friday, the respondent's counsel was provided with additional information which we sought leave on Friday before this honorable panel. Now that information, counsel was not apprised of at the time of completing the witness statements. And so it is in respect of these documents and this witness's statement on the risk of cancellation that I would like to ask a few questions. It's not going to be a long, protracted process, please, Mr. Chairman, but it is in respect of these additional documents that were placed before the commission. Not the commission, sorry, the hearing panel. Apologies.
Ms. Rose, thank you. Ms. Fitzpatrick, a brief comment before the panel breaks to discuss.
Yes, very brief. I would like to say that if that were the case, please, I would have appreciated if my learned friend had indicated that before we called the witness and before I cross-examined him. Because what is being suggested is that this is information, or the need for eliciting further evidence was known since Friday, or that this would be relevant. And what has happened is I have just finished my cross-examination and further questions are being asked. And I will only leave it at that, please, Mr. Chair.
And may I respond to that before? Mr. Chairman, according to these rules, you can regulate your own proceedings and you must be flexible. And according to the regulations, you should not be bound by the technicalities of court and the Evidence Act and all of that. And I would respectfully have no objection whatsoever to my learned friend being permitted to cross-examine on this additional information that we would like to lead. And I would respectfully say this. I was awaiting for my learned friend to complete her cross-examination, because it may have been, had she cross-examined on the portions relating to the cancellation of the process, the information would have been available. And so have her decision not to do so makes it demands that in order for this honorable panel to have all of the information relating to the cancellation, which was not readily available to counsel at the time of settling these witness statements, it redounds upon us and the panel to, I'm urging and asking that we be allowed to elucidate this issue of the risk of cancellation, because without this elucidation, the honorable panel could be led into error in respect of the cancellation of these termination proceedings, cancellation of these procurement proceedings, please.
Thank you, Ms. Rose. Having heard both parties, the panel will take a short break and decide upon the issues raised, and we will be back shortly with a decision.
Thank you.
Malika, Sandy, you're still off camera. Thank you, Ms. Sandy. Before the panel gives its decision, Ms. Sinat, on behalf of the interested party, do you have anything to contribute to the issues just raised?
Thank you, Mr. Chair, that I join in the respondent's application, please. And we support this application being made.
Thank you, Ms. Sinat. The panel has discussed the application made. And yes, we do know that we have the ability to regulate our own proceedings, and we have discussed the issues at hand. And one of the critical things about this application is at the moment it has been made, the representative of the respondent could have taken the opportunity to do a brief evidence in chief prior to cross-examination, thereby allowing the documentation to be referenced or raised before Ms. Fitzpatrick got the opportunity to cross-examine the witness. As such, the panel will not allow the application at this point in time, will not allow the application.
Grateful, Mr. Chair. Mr. Chair, just again, for the record, sorry.
I'm much obliged, Mr. Chair. I would want to put on record that therefore we have not had the opportunity to lead evidence in respect of the additional documentation that has been put before the honorable panel. There was an attempt to ask questions of Ms. Suklal Singh in respect of those those documents, and we opted to, after there was objection taken, to wait for other witnesses that were dealing with the cancellation of the process. None of the witnesses dealing with the risk of the cancellation of the process who had put in witness statements dealing with that were cross-examined on the issue of the risk of the cancellation of the process. There was also an application made today to have the interested parties witness come to give evidence in respect of what happened between a particular timeline which has relevance to this issue of the risk of cancellation. And now we have been denied the opportunity to put before this honorable panel relevant material evidence about the risk of cancellation of this procurement process. We sought, because of our duty of disclosure, to put before this panel the aviation policy and the motor vehicle insurance policy that was negotiated by the interested party when they were operating under de facto authorization given on August 16th. And elucidation is required so that the panel understands the linkage between the cancellation of any order to cancel these procurement proceedings and the aviation policy and motor vehicle insurance policy cover for the year that has been put before this honorable panel. If this information is not before you, you could be led into the error of thinking that regardless of what you do here, the aviation policy and the motor vehicle policy coverage for the next year remains in place. And I am asking again for this honorable panel to reconsider this decision here this afternoon, because your decisions, please, Mr. Chair, must be proportionate to the importance of the case, the complexity of the issues, the anticipated costs, and the resources of the parties. And if I, as counsel for the respondent, has indicated to you that we have absolutely no objection to counsel for the applicant cross-examining on any new information that is elicited through a couple further questions that I may ask this afternoon on I have already been very open with this panel on the policies that were lately submitted before this honorable panel. Then this honorable panel will not have the relevant information in order to make a fair and just decision, a decision that must be proportionate to the importance of this case. And this case is not just another procurement proceeding relating to the acquisition of fixtures and furnishings or construction project. This is aviation policy and motor vehicle policy that is linked to public health, public safety, and the rights of citizens of Trinidad and Tobago. And so the implications of canceling this process in the context of what we have put before this honorable panel is material. And I hope that perhaps I can urge the honorable panel to reconsider. I see Millennium Friend's hand is up.
Mrs. Patrick? Your hand up, Mrs. Patrick? You're still on mute, Mrs. Patrick.
Apologies, Mr. Chair. The application that was made on Friday to put in these further documents was, as I understood it, really limited to that. My friend did say that Mr. Klal Singh would be giving further evidence. When asked whether she intended or whether the respondent intended to file a witness statement, the respondent said that they would be, the evidence would be given viva voce. The record will show that when I took an objection this morning, it was not to what my friend is now saying Mr. Pearson is coming to say. And it was very clearly the reason that she did not pursue the questions is because she very clearly said, yes, this information is contained in the evidence of other witness statements before this panel. So that it is, I don't think it is fair to say that she was, or suggest that the respondent was somehow obstructed this morning by my objection from putting in the evidence that was the subject of the application. That is not what took place. And it could not be, Mr. Chair, that my friend is relying on my cross-examination to get out certain information that it says is so crucial and that the public interest hangs on this. It could not be for my cross-examination to raise that. So I'm quite surprised that the application is essentially before you asking you to change your decision. And I see that is really, I mean, the attempt is to really strong arm this panel that has exercised its very wide powers, knowing full well what its powers and duties are under the Act and the regulations, because of some alarmism that, quite frankly, that's a matter for submissions.
But Mr. Chairman, please, the reason that the honorable panel has used for not allowing this application, not granting us the ability to, is that counsel should have asked this at the beginning of the evidence in chief. I would respectfully urge this counsel to have regard to the overriding objective in the hearing rules of these proceedings, which is about avoiding unnecessary formality and seeking flexibility in the challenge proceedings. It cannot be that because counsel didn't take the point before, counsel cannot take the point now. That is being overly technical, overly formal, and unfair to the respondent's case when we have indicated that we have absolutely no objection to the applicant's counsel cross-examining on any additional information that has been provided before the panel. So this is not an attempt to strong arm. This is an attempt to ask this honorable panel to have regard to its overriding objective, which is expressly set out. How is it fair that in these kinds of proceedings, we are to come here and to be, held to the very same rules that we are held to in court? There's a reason why this panel has been set up in this sort of expedited 20-day procedure. There is a purpose behind this process, and the purpose is for the panel to be able to get at the meat of the issues as quickly clear as possible and not to be overly formal and overly technical. And these are my respectful submissions, please.
Thank you, Ms. Rose. If I may go back in time a little bit, on Friday, the panel would have been advised of some new information that would be provided to the panel, and we did give leave to allow the respondent and their representative to provide such documentation. As a matter of fact, we allocated an hour and a half to give the representative of the respondent the opportunity to source and to provide those documentation, notwithstanding witness statements would have been filed before. So the panel has been very accommodating so far. Additionally, on Friday, when the issue of the new documentation was raised, the panel would have been advised that these new documents would have been raised primarily or would have been raised with witness Ms. Suklal Singh. That being said, I am now going to take a very short break, confer with my panel members, and we would give our final decision shortly. Ms. Bermudez-Lucky, your camera is still off. Thank you. Ms. Rose, Ms. Fitzpatrick, the decision of the panel stands as regards the last direction we gave on this matter. However, we do wish to advise that you do have the opportunity to vent further with your closing documents. So may we continue, please?
Thank you. Mr. Chair, just for the record, I had no further questions for Mr. Pearson.
Ms. Rose? Interested party, do you have any questions of the witness?
No further questions for this witness, please.
Thank you, Ms. Sinat. The witness is now
Obliged.
relieved.
Mr. Chairman, honorable members of the panel, that was our last witness.
Thank you, Ms. Rose. At this point in time, I would like to confirm from the parties if you wish to rely on your written submissions filed on the 10th of October 2024, or if you wish to make any closing oral submissions or file final closing submissions on the 15th of October 2024. Applicant?
Mr. Chair, can I just confirm, if we make oral submissions today, we are not precluded from filing the written submissions?
No, you're not.
No, we're not. Well, in that case, I would probably opt for both of those directions. I mean, I'm not sure whether my filing of written submissions is dependent on what the other parties decide to do.
Ms. Rose?
Yes, I would like the opportunity to file written submissions tomorrow, please.
Just to be clear, written submissions only, you would not be relying on any oral submissions this afternoon?
Well, if my learned friend makes oral submissions, I too will make oral submissions.
Mr. Fitzpatrick, just to be clear, you are making oral submissions this afternoon. You're taking yourself that opportunity.
I will be very, very brief. But, well, I will try to be very brief.
Okay. Interested party?
Thank you, Mr. Chair. Yes, we will be reserving our right to file same.
Both, just to be clear, both oral and the final written?
Yes, please, Mr. Chair.
Give them a kind of. Given the option chosen by the applicant, the respondent, and the interested party, do you all need time to prepare, or do you wish to go right into the proceedings?
Mr. Chair, I would just like a very short break, just to have some water and so on before closing, if the panel would permit. But I don't need more than 10 minutes, 5 minutes, depending on what the panel permits.
We are flexible. Ms. Rose?
No objections, please.
Ms. Tinat?
No objections.
Okay. The panel will grant 10 minutes,
Thank you.
following which we would have the submissions. With regard to the closing oral submissions, we will invite the applicant first, then the respondent, and then the interested party. Mrs. Patrick, are you ready?
I am, Mr. Chair. Thank you.
Please proceed.
Members of the panel, Mr. Chair, for decades, this country has been plagued by allegations of favoritism and corruption in the award of public contracts. And whether those are founded or unfounded, we know that this legislation, the legislative framework, the Public Procurement and Disposal of Public Property Act, was enacted with very clear objectives, please, that are set out, as you're well aware, in Section 5 of the Act. This panel is entrusted with the responsibility of ensuring compliance with the provisions of the legislation and the regulations. And in doing so, it is reminded with the utmost respect that it is a creature of statute and its powers and duties emanate from and are very clearly defined by the Act. So we submit that when this panel is being asked to exercise any power or discretion, as the case may be, the panel must first ask itself, from where do we derive this power? The panel is urged not to forget its own statutory mandate, which is aimed at, among other things, ensuring transparency, accountability, and ensuring public confidence in the procurement process. And we see in these proceedings that it is clear that the procurement process was flawed. Agostini Insurance Brokers Limited alleges that Civil Aviation awarded the procurement contract to the interested party in clear breach of the terms of the Act. And I'm referring to the Procurement and Disposal of Public Property Act when I say Act, please. In particular, the applicant submits that Civil Aviation failed to observe the standstill period, which is clearly required not only by the statute, but which it was included in its own RFP. And as a result, please, we say that AIB has been deprived of the opportunity to file an objection or seek clarification on the results of the evaluation that contributed to it being unsuccessful, despite providing the most competitive bid. And that is highlighted by what has in fact transpired in these proceedings, we say, which has been essentially that through the respondent's reply, AIB has become aware that the respondent applied criteria to the evaluation of the bid, which is not set out in the bidding document, in the evaluation of the proposals. And that in doing so, it in fact deprived it of being the most successful proponent. I'll turn first to the decision of Civil Aviation to disapply the standstill period, which we say is unlawful and without justification. As the panel will be well aware, Section 35(4) of the Act permits a procuring entity to disregard the need for a standstill period where there are urgent public interest considerations. And we say that in the circumstances where the procuring entity's bidding document contains such a standstill period, as a matter of common sense, as a matter of common sense, the standstill period must apply, or Section 35(4) rather, must apply only to urgent public interest considerations which arise after the issuance of the bidding document. Because if one includes the standstill period in the RFP, it must be that there were no urgent public considerations at the time. In the present case, please, Mr. Chair, it is not disputed that this RFP contained a standstill period of 10 days, and that notwithstanding that standstill period, the Civil Aviation Authority proceeded to award a contract without issuing the notice required by Section 35(2) of the Act. In justification of this Act, it relies on the expiration of its current contract for insurance brokerage services and says that it had to expedite the procurement of an insurance broker so as to guard against any possible lapse in its coverage. We say that it is not open to Civil Aviation to raise urgent public interest considerations in circumstances where the RFP expressly provided for a standstill period at the time that it was issued. We say so because at the time that the RFP was issued, Civil Aviation, and it is clearly demonstrated from the evidence, was fully aware of the date of expiration of its current insurance brokerage services contracts. And more than that, it was fully aware of the time that would be required, not only for the transition of brokers, but for negotiating and renewing the new policy contracts. It must have satisfied itself that there would have been sufficient time between the award of a contract and the expiration of its current contract for insurance brokerage services, and it is simply not sufficient to avoid the consequences of the act to say, well, things arose which we did not cater for. Things arose which we did not cater for, which we ought to have catered for, is our submission. The respondent, in its opening submissions, has stated that it is uniquely positioned to evaluate the unique and complex requirements of aviation insurance policies. And we say simply that having that experience, they ought to have known that they ought to have known how to fix their timelines to ensure both that they could avoid any possible risks and that they could comply with the law. It is also relevant, we say, to note that the decision of a procuring entity that urgent public interest considerations exist, and the reasons for the decision must be included in the record of procurement proceedings as provided by Section 35(5) of the Act. Civil aviation has produced no evidence at all to satisfy this requirement. In fact, we say that the lack of any contemporaneous documents with regard to this decision to waive the standstill period demonstrates that there was no real public interest concern at all, urgent or otherwise. We say also that the respondents' alarmism about the alleged grave and imminent risks to public health and safety is not supported by the factual matrix in this case at all. There is not a single piece of internal communication documenting these concerns. It is plain from the evidence that civil aviation is in fact relying on its own failure to fix internal timelines as the basis for waiving the standstill period, and that from that certain things could have flowed. The point is, please panel, that it possessed all the relevant knowledge to avoid unnecessary delays at the time of issuing the RFP, or ought to have. And in other words, we say that nothing changed between the issuance of the RFP and the waiving of the standstill period, which would have justified doing so. What they essentially have been saying is we needed to take back those 10 days to fix our oversight. Notwithstanding the claims of urgent public interest concerns, the respondent took no urgent steps to proceed with the procurement, and the timeline of events demonstrates that there was more than enough time for civil aviation to comply with the standstill period, which was only 10 business days. So in these circumstances, we say simply that there were no urgent public interest considerations under Section 35(4), which justified proceeding with the procurement process without a standstill period, and that the respondent is relying on its own conduct to circumvent its statutory and contractual obligations, which is simply not fair. Finally, even if there may have been a risk of a lapse in insurance coverage period, which we deny, civil aviation had a short-term solution open to it in the form of temporary extension of its current insurance policies. And no good reason has been advanced by the respondent for not pursuing these. The respondent has in fact now given evidence that it was able to secure new policies in a short time frame, and we say that this demonstrates the ease with which they were able to avoid any risk, please. I move on now to deal with an issue that was raised in the Form 8, which was whether civil aviation had adjusted AIB's bid. And we asked the panel to note that the respondent has now admitted that AIB's bid was misstated as a result of an arithmetical error on its part. AIB, of course, was not aware of this until these challenge proceedings were filed, and we say that this really highlights the lack of transparency in the process. More importantly, we say that what has now come out of the evidence is that AIB would have been successful had the bid been properly calculated. And I would like to deal with this issue, which really is the question of whether civil aviation has applied some evaluation criteria and methodology that was not specified in the RFP. The evaluation regulations panel, of course, set out that evaluation criteria and methodology to be applied by a procuring entity in selecting a successful submission must be specified in the bidding document. The evidence has clearly shown that the non-price factor, that is the technical criteria, was specified in the bidding document as being a pass-fail basis only. It is not disputed that the applicant passed this aspect of the evaluation. It is also not disputed that the applicant submitted the most competitive commercial bid, which we say would necessarily result in this proponent having been ranked first. The respondent has ranked Gallagher first on the basis of weighted criteria, which appears nowhere in the bidding document, and is, we say, in fact, inconsistent with the predetermined evaluation criteria that was made known to the suppliers. That is in direct contravention of the Act, please, and as such, we say that the award is void and illegal with reliance upon Section 6(1) of the Act. Insofar as this panel is being asked to treat with this respondent in some special way, notwithstanding clear breaches of the Act, we submit that there can be no scope for that. That would simply be at odds with the objective of the Act entirely. There will always be industries which by their nature involve public safety concerns and risks to the public. The mere fact that an entity is operating in those areas does not mean that they are excluded from the Act. The respondent is asking this panel to cede its jurisdiction to this company because of claimed specialized areas of activity. The Act makes no provision for any special categories. Where any special categories, in the words of the respondent, where public interest overrides compliance. If the drafters had intended it to be so, it would have been done. And in fact, the Act only makes reference to public interest considerations with respect to a decision to waive the standstill period. So really that public interest considerations beyond that are not for this panel to consider at all. Otherwise, the argument could extend to any public health and to any industry, public health, crime, education. What we are saying, please, is that this company, this respondent is not above the law. Otherwise, entities would simply be able to circumvent the legislation by raising that they operate within some specialized area. We also say, please, Mr. Chair, that these are very early days of this legislation and this panel, and it is very crucial in these early days to not erode the public confidence in this process. The Act mandates that public bodies are to comply with the provisions of the Act in carrying out the public procurement procedure, and it provides very strict sanctions for the failure to do so. As such, we say that it matters not whether had the procuring entity bypassed the procedural requirements, the result would have been the same anyway, which is a matter that has been raised by the respondent. And we, in the written submissions, will rely further on authorities which make that very clear, that that is not a consideration. It also matters not that having breached the Act and having committed its own act or omission, through no fault of the suppliers, the procuring entity is exposed to risk or harm, or has exposed the public to harm. That is not a consideration under the Act. And with respect, please, to the new issue that has been introduced, which is the issue of the effect of any decision of this panel on the rights of innocent third parties. I will address this in greater detail in the written submissions. I have already given some oral an oral address on this point, but I just wish to reiterate that Section 6(2) of the Act does not and could not have been intended to make valid an award which is illegal under this Act. It is intended instead to preserve the contractual rights of third parties under those third-party contracts. So for those reasons, which will be elaborated in the written submissions, we say that Civil Aviation's award of the contract of services to Gallagher was not done in accordance with the Act and is simply void and illegal as per Section 6(1) of the Act. And this award must be overturned and the bids re-evaluated in accordance with the RFP. Unless I can be of further assistance to the panel, those are my closing submissions.
Thank you, Ms. Fitzpatrick. Ms. Rose?
Mr. Chair, my submissions will be taking the form of the written submissions tomorrow. I will just respond to some of the factual matters raised by my learned friend in her closing submissions. We accept that we are at the earliest stages of the implementation of this new regime and this Office of Procurement Regulator's mandate. And we accept that it is very important that the Office of Procurement Regulator acts with caution and acts appropriately in accordance with the overriding objective of this Act, and makes decisions that are proportionate, that can set precedent for how public sector bodies should operate in the context of this very important function. We are ad idem with my learned friend, with the applicant counsel on that point. Firstly, we say that we have adduced evidence from the witnesses of the respondent that there were urgent public interest considerations that caused them to make the decision to waive the standstill period pursuant to Section 35(4). That's the first issue I would briefly address. What my learned friend did not state in her submissions and did not refer to was the evidence of Mr. Felix Pearson in respect of what intervened after the inclusion of the standstill period in the RFP and the time, the date when the decision was made to waive. And what intervened were the numerous requests for clarification, the addenda that was done, the extensions of time that were asked for by the bidders. And then in the evaluation process, the various different options that were given by each of the bidders, as outlined in the witness statement of Ms. Rhonda Sukul-Alsing, and which was reiterated by Mr. Felix Pearson, that given all of those intervening circumstances, although the initial schedule for this particular RFP, there would have been sufficient time to do the standstill period, and there would have been sufficient time to do the evaluations and also secure the aviation, the general insurance policies and the Guardian and the general health and life insurance policies before September 30th. Because of these intervening circumstances, the Trinidad and Tobago Civil Aviation Authority found itself in a situation where, because of the relationship between insurance brokerage contracts and the underlying aviation policy, that they would have been suffering a lapse in coverage had they not moved very quickly to make the award and trigger Gallagher, the interested party, to begin the process for securing the general insurance's policies, which we have put before the hearing panel. So that there was an intervening circumstance, which is inconsistent with my learned friend's submission that nothing changed. And it is clear that several things occurred that caused the initial deadline of June 21st to shift. And even when the Trinidad and Tobago Civil Aviation Authority took the decision to accept new bids on July 5th for a new deadline on July 5th, there was an internal timeline set to have the evaluation process finished by July 19th. This is the evidence that is before the honorable panel, and I would say it is evidence that is not refuted. So it is evidence that they intended to finish on July 19th, but based on the various options, they were not able to complete it in that time frame. And it is in that context that at the beginning of August, it began to be realized that they were cutting it extremely close in order to secure this very critical cover in particular respect of the aviation policies and the motor vehicle insurances. And Mr. Chairman, it is very important that we understand that this as well was also the first time that the Trinidad and Tobago Civil Aviation Authority was consolidating its insurance cover. And even though the general health and life insurance cover may not have lapsed because it was now being pursued in a consolidated format, then this is why it was felt that the entire procurement proceeding had to be expedited and they had to waive the standstill period. It is our respectful submission that it is the Civil Aviation Authority who understands the complexities of insurances in this particular industry and the time frame that is required for the negotiation of these insurances and the relationship between insurance brokerage contracts and the general aviation policy. In our respectful submission, even if what my learned friend has submitted is correct, which we do not accept at all, but even if it is the Trinidad and Tobago Civil Aviation Authority did not have its schedule right and should have treated with this with more urgency from long before, which we are not accepting that is the case. But even if that is what my learned friend is submitting, we are respectfully stating that the fact that there are urgent public interest considerations with respect to aviation policy cannot be put side by side in respect of the conduct of TTCA. The conduct of TTCAA is irrelevant in the context of the urgent public interest considerations. The fact that the traveling public, the fact that the public safety is in jeopardy, this is not alarmism, this is a fact. The fact that the traveling public's safety is in jeopardy, the fact that contingency arrangements, funding for contingency arrangements, should, God forbid, something happen in respect of air travel and in our air service navigation space, if there is no coverage, this can have catastrophic consequences, not only for the parties, for Trinidad and Tobago Civil Aviation Authority, but for the government of Trinidad and Tobago that must underwrite this situation and for the global obligations. But I will seek your leave to explicate these submissions in writing tomorrow, and that is in respect of the waiver of the standstill period pursuant to section 35(4). And in that respect, I would put before the honorable panel the evidence of Mr. Mitcham Narayan Singh, in which he indicated that on his interpretation of section 35(4), Under section 35.4, it says section 35.2 will not apply where a procuring entity deems that urgent public interest considerations apply. And section 35.2 deals with the notice. So he was operating under a very strict, literal interpretation of the sections. And I am not here trying to advance a case in respect of Mr. Mitcham Narayan Singh's interpretation of those sections, but his interpretation is correct on a literal construction of those sections. That 35.2 requires notice to the unsuccessful proponents in the event of a standstill, a letter of intent being issued. It requires notice. And then 35.4 says, if the procuring entity deems that there's urgent public interest, then 35.2 does not apply. I accept that this is a very literal interpretation, but in my respectful submission, it was a good faith interpretation of the principles. And I am respectfully submitting before this honorable panel that when there is good faith mistakes being made by a procuring entity and procedural non-compliance, if the panel is so to find that is being undertaken in good faith, this factor must be a relevant consideration if the panel must make decisions that are proportionate to the harm that can arise. And we are saying, we have put before you several witnesses. In fact, we have gone over and above in terms of our disclosures. The only disclosure we have not put would be the commercial proposals of the other bidders, and this we did out of respect for the confidentiality concerns in relation to those commercial proposals. But what we've done is we've placed before you the evidence of several employees, very high-ranking employees in the Trinidad and Tobago Civil Aviation Authority, none of whom have been found to be in any way dishonest in the evidence that they have given before this honorable panel. And this is an important factor that I would like to raise. If these officers were acting in good faith, we are respectfully submitting that this panel should take into consideration such good faith action, even if there are errors. If it was done in good faith and there can be no allegation of dishonesty, no allegation of fraud, no allegation of collusion, no allegation of bid rigging, there is absolutely no allegation of misfeasance in this matter. What is before you are the good faith actions of a procuring entity that is in a singular position to assess public interest considerations as it deals with, as it relates to aviation insurance coverage and motor vehicle insurance coverage in the context of aviation, in the context of the aviation industry. So this is my submission in respect of the waiver of the standstill period, given the urgent public interest considerations. Now, please, Mr. Chairman, on the point raised by my learned friend on the failure to document urgent public interest, it is wholly wrong, I would say, for you to accept a submission that because there was a failure to document the urgent public interest considerations, that therefore means that there were no urgent public interest considerations. These are two completely different things, whether it was documented and whether it in fact exists. And I am respectfully submitting that this honorable panel in making a decision that is proportionate, that the evidence is from these witnesses, and it is quite extensive, where they have outlined the urgent public interest considerations that they were having regard to when they made decisions in respect of, and I am urging this honorable panel to have regard to the evidence that is before it in respect of the urgent public interest considerations, as opposed to being led away on the suggestion that because it wasn't documented, it did not exist. Now, in respect of the intervention of third-party rights, we have sought to bring before the Commission, before the Honorable Panel, on our duty of full disclosure. We did not have to do it, but we sought to do it on our duty of full disclosure, that aviation policy and the motor vehicle policy has been initiated, has been executed. The argument in respect of third-party rights, which we will seek leave to elucidate in the written submissions, is not about two parties to a contract and a contracting party having rights and that being preserved under Section 6.2, so that the aviation insurance provider, if the lapse of the brokerage contract will result in the lapse of the aviation policy. This is not that the aviation policy insurance cover provider can bring action against the procuring entity. This is not the argument in respect of third-party rights. The argument is insurance policies are of a particular specificity that brings other types of third-party rights, including the insurance provider, but also the beneficiaries of the insurance cover that is in place that will lapse. It is the beneficiaries, which include the public, the citizens of Trinidad and Tobago, the government of the Republic of Trinidad and Tobago, their safety, their security. These are the innocent third-party rights that we are also advancing before and seeking to protect and seeking to ask the Honorable Panel to weigh in the balance. Here. So, Mr. Chairman, I would ask if there are any other questions that you would like me to address you on, and or pursuant to your powers under your hearing rules, are there any further documents that you think are material and relevant to the issues before you that you would like us, the respondent, to provide to you before we close?
Ms. Rose, that's the end of your submission?
Yes, so I'm asking at the end of my submission, if there is any other issue you would like me to specifically address, and if there are any other documents that the hearing panel thinks is material and relevant to the issues that they have to consider, the issues that have been brought before the commission. I'm asking if there's anything else that we can do to assist you.
Thank you, Ms. Rose. In respect to your last, the panel will hear the interested party, and then we would give you guidance on your last question.
Very well, thank you.
Interested party?
Thank you, Honorable Panel. The interested party would first like to start off by thanking the panel for the opportunity for oral submissions given the peculiar position of the interested party. Our submissions are, given the purpose of the OPR and the main spirit and function of the OPR, to deal with cases fairly, justly. We believe that the applicant's relief sought here would be a complete abuse of process. It would be a waste of resources, and more importantly, it would open the floodgates at this early stage of functioning of this very critical and important body. Furthermore, it is the interested party's submissions that the panel ought to consider the specific services being sought through the tender process and by extension, the RFQ. We respectfully submit and request that these services be carefully weighted, especially having regard to the fact of the implications which can arise as a result of cancellation of the policy. Any losses sustained as a result of this uninsured period will not only result in exposure, but can lead to exposure at the sole expense to the government and/or state. It is our submission, or rather the submission of the interested party, that even if the panel upholds the applicant's case, which the interested party is not in agreement with, having regard to the argument that the respondent, i.e. Civil Aviation, failed to follow proper procedure as prescribed by the Act, it is our submission respectfully that the respondent has properly cured all irregularities. And therefore, it is our respectful submission that there is no need for the award to be overturned. In short, these are the submissions of the interested party, please.
Thank you, Ms. Sinat. And all are reminded that the closing date for your written closing submissions will be the 15th. Ms. Rose, with respect to your requests for the panel requiring additional documents, we trust that all of the relevant documents are before us. So there are no specific documents that we require to see at this point in time.
And on any particular issue, additional issue that the panel would like us to prepare written submissions on, if there's any other issue.
In terms of, we would like all parties to consider the Form 15 that was submitted by the applicant in your written submissions. Ms. Sinat?
Thank you, Mr. Chair. Just a matter of housekeeping, we have not been served with the applicant's Form 15, please.
Ms. Fitzpatrick?
Yes,
Could you ensure?
Mr. Chair, and my apologies to my friend. I did see her email while the hearing was going on, so I will forward that to her as soon as the proceedings are over.
Yes, please,
Thank you,
Mr. Chair. We will address Form 15 in our submissions.
Thank you, everyone. At this point in time, the panel would like to thank all parties, representatives, witnesses for their participation and assistance in this matter. This would bring us to the end of the hearing. However, in terms of next steps, I would like to outline the following. The decision on this matter would be given on or before the 18th of October 2024 in accordance with Section 5011 of the Public Procurement and Disposal of Public Property Act 2015 as amended. It will be issued to the parties by way of email from the hearing secretary. The written reasons are statutorily due within 30 days after the panel's decision is given in accordance with Section 5012 of the PPA. However, the panel will endeavor to provide same before the expiration of that period, and it will be issued to the parties by way of email from the hearing secretary. Thank you once again for your participation in this matter, and I bid you all a great evening. Have a great day, rest of the day, everyone.
Much obliged.
Thank you very much, and same to you, members of the panel, Mr. Chair.
Thank you.